Hello, it's great to see so many of you here today. Thank you very much for joining us. I'm Geraint Wheatley. I'm a 20 years call from King's Chambers. Matt is with me too, Matt Hall, also from King's Chambers. He's 22 years call. The focus of today is going to be on witness statements under the new practice direction in the business and property courts. Thank you very much to the PLA and in particular to Elizabeth Cape from Addleshaws for inviting us to speak to you today. We are not going to slavishly go through the full practice direction and the statement of best practice. There's plenty of seminars that have dealt with that sort of thing already. Matt's going to be focusing on probably the most difficult area under this new regime, which is the treatment of documents. I'm going to be running through various thoughts and practical tips about how we deal with things these days. I'm going to talk about what case law there is and conclude with a brief discussion about judicial notice. At first, we thought that we would be able to include discussion about the divide between evidence of fact and evidence of opinion. But as we were preparing the seminar, the subject grew to the point where we didn't think we'd be able to do any of it justice if we tried to shoehorn that in as well. So we've had to leave it out. So before turning to Matt to kick off, just a couple of points. Any questions, if you use the Q&A function, and we'll deal with any that we're able to in the time available at the end. We're also going to run some polls, which I'm going to launch now for you. We've got the first one being, do you think that the new practice direction has already improved the trial process in the business and property courts? Now, we haven't been doing it for that long, so it may well be that a lot of you don't know as yet. The reason we've put this in is that back in February, the Leeds Business and Property Court Forum ran a seminar about the forthcoming practice direction. And they asked a question basically like this. So I'm not going to tell you the results of that until the end, but I thought it might be interesting to see whether attitudes have changed. So that's that question. There are other questions as well, which I will come to in due course. And with that in mind, I'll hand over to Matt.
Hi everyone. Right. Oh, Geraint, could you just take the oh no, I've done it. Right, okay. I'll start by telling you what I'm not going to do. I'm not going to just go through what practice direction 57AC says. Basically, it's got three interlocking parts: the practice direction itself, the statement of best practice, and two certifications, one for the witness and one for the legal representative. It also cross-refers to the practice direction to part 32. The statement of best practice is of course a misnomer. It's not a best practice guide at all, because the legal representative has to certify that they believe that the statement has been prepared in accordance with the statement of best practice. So in effect, it's a mandatory rule. If you want a summary of what the practice direction says, this is the best one that I've found, 138 words by retired District Judge Stephen Gold, who writes the regular Civil Way column in the New Law Journal. All I'll say is just look at the last bit that I've highlighted there from Stephen's summary. I'm not going to just do a talk practicing the criticising the practice direction. It is at first sight a bit hard to follow in its drafting. One wonders how it will work in practice, particularly the sort of interview that it sets up for us to do with witnesses. as a sort of mini examination in chief, which I'll come to later. The fact is that it's here and we've got to deal with it. And I'm not going to do a general talk on how to do witness statements. A great talk about that is the snappily entitled one by my colleague in Chambers, Richard Lander. That deals with a lot of the pitfalls that the new practice direction was introduced to tackle. What I want to deal with is the question of documents, which I think, as Geraint says, probably is the most difficult part of all of this. The basic question is, of course, what documents will help me to prove my client's case, and how do I put those documents in evidence so that they can be relied on at trial? And with that in mind, I think we do have to look a bit at the core provision about what one of these new trial witness statements actually has to deal with. This is at paragraph 3.1 in the practice direction itself. So it says, the witness statement must deal only with evidence as to matters of fact that need to be proved at trial. Well, so far, so good. And then it goes on, and it says, the evidence as to such matters the witness would be asked by the relevant party to give, and that the witness would be allowed to give in evidence in chief if they were called to give oral evidence at trial. So an immediate query arises: what, apart from the necessary facts, is evidence in chief about? And here we have to go back in time, because the practice of exchanging witness statements was brought in by an amendment to the rules of the Supreme Court in 1986. So that was the heyday of evidence in chief. And I repeat, the practice of exchanging witness statements was only brought in then. At that time, witnesses wouldn't do a statement, and they would just turn up at trial and give their evidence almost, as it were, off the cuff. I mean, you would know what they were going to say if they were your witnesses, because you would have taken a proof. So just imagine that, no previous exchange of statements, witnesses just turning up. It must have been great fun, I suppose, in many ways. Peculiarly, looking at the material from the time, as I did briefly, the elimination of the element of surprise at trial was regarded at the time as being quite revolutionary. It was part of the new cards on the table approach. But what the new rule did was that it allowed witness statements to be treated as evidence in chief. And that practice of doing that grew and grew and grew until eventually it was embodied in a practice direction which came in 1995, so 3 years before the civil procedure rules. The Witness Evidence Working Group, which wrote the report and did the preparatory work, considered that in many ways the fact that evidence was coming straight from the horse's mouth at a civil trial in the 80s might have made it more genuine. That's in their report, you can see, which I've extracted on the slide here. The common experience of witnesses not coming up to proof in oral examination in chief was a reflection of the fact that evidence elicited orally in the courtroom surroundings is often more reliable. Of course, it's horrible if you're the advocate at trial when your witness goes completely off script. But judges liked it because, so far as they could see, it would pierce the veil of the over-lawyered statements, which were perceived to have been the problem which led to the reform. Judges do sometimes ask for examination in chief to be done in civil trials. It's very rare, but it does still happen. If there's a particularly crucial event in the whole case, sometimes judges can ask for evidence to be led. It's happened to me a couple of times. In fact, it was in the 2 times it did happen was in wills cases, where the evidence about the will appointment was absolutely crucial. Paradoxically, of course, the practice direction doesn't actually apply to probate claims. I don't know whether, Geraint, whether you've had any experience of being asked to do evidence in chief.
No, never. It's you have a few questions at the start, but no, I've been fortunate enough to avoid that one.
So I mean, it's quite difficult really to find out what evidence in chief has to be about. You go back to the slide. What evidence is it that the witness is allowed to give in evidence in chief over and above the facts necessary to prove the case? This is what I found in Phipson on evidence. So it's not just the primary facts, but also things which will make a witness the witness's evidence more credible and reliable, opportunities for observation, reasons for recollection and belief, and other circumstances affecting the reliability of the evidence. But it is quite difficult to find what such evidence is supposed to be about. So anyway, back to documents. So with that in mind as what the statements have got to deal with, let's just talk then about exactly how they have to put the documents in. The first thing we see is that there's got to be a list, and the list has to refer to the evidence, the documents, not just that the witness is going to refer to, but also the documents that he or she has been referred to. So let's just take this in stages. Firstly, what documents should be referred to a witness in the preparation of a trial witness statement? And here we already run into some uncertainty, in my opinion. The statement of best practice in paragraph 2.1 reminds us again about this elusive evidence in chief restriction, and says that the content of the trial witness statement must also be given as if the principles set out in paragraphs 2.2 to 2.6 were followed. 2.6 then refers to the fact that during evidence in chief, the witness's memory can be refreshed by looking at a document, but only if the witness created or saw the document while the facts evidenced or being referred to were fresh in their mind. Now, just pausing there, it's difficult to know whether this part of the practice direction means that when you're doing an interview with your witness to prepare the trial witness statement, whether you can only show the witness the documents that would have been fresh in their mind at the time of the events. Now, what that's referring to there, fresh in their mind, is a rule to do with examination in chief. So when a witness is giving evidence in chief in the witness box, they might say, "Oh, I can't remember about such and such an event," and the advocate is allowed then to allow the witness to refresh their memory from a document that they might have prepared nearer the time. Typically, this will happen in criminal trials in evidence when the witness says, "Oh, I can't remember, but I did give a statement to the police nearer the time." And the witness is allowed then to refresh their memory by reference to such a statement. So is it saying then that the interview to do a trial witness statement has to be done a bit like a mini examination in chief? Can the witness be shown all the other documents in the case when you're preparing a witness statement to look at all of the documents generally? I think the answer is yes, they can. And the reason to reach that conclusion is actually in the statement of best practice at paragraph 3.4, where it says particular caution should be exercised before or when showing a witness a document they did not create or see while the facts evidenced or referred to in the document were fresh in their mind. So it does look as though you can do it, but of course those documents, if they're not going to be referred to by the witness, and we'll come on to those documents in a minute, they're going to go in the list. And you might think that the more documents that are in the list, the more likely it is that a submission might be made that the witness evidence lacks the sort of spontaneity that the practice direction was obviously intended to enhance. Exercising particular caution, obviously, it says in the practice direction, means avoiding asking leading questions. The legal representative is also required to keep a note or a recording of the interview. And a clue about this is, in any event, in one of the first decided cases about the practice direction, or at least mentioning the practice direction. The facts of this case don't really matter. Safe to say that the defendant company was under a duty to provide accurate purchase forecasts. And it accepted that there came a time when their forecasts were no longer accurate. The witnesses, and again this was accepted, were in their witness statements very vague about the precise time when the forecasts became inaccurate. And in submission on behalf of the defendant company, counsel said, well, that's all that we could do. That's what witnesses should be doing. They should just be going off their memory. And if that means that they're vague, then they have to be vague. The documents were created 8 years ago, and some of the documents would never have even been seen by these witnesses. So that's what the court's left with. And that submission was interestingly rejected quite firmly by Mr. Justice Jacobs, who said that the witnesses could, and indeed probably should have been shown, the large, substantial body of contemporaneous documents in providing their statements. And crucially, his lordship said that the same would no doubt be the position, at least in his view, under Practice Direction 57AC, because in his lordship's view, that contemplates that witnesses will be shown contemporaneous documents, particularly those which they have previously seen when the events were fresher in their minds. So it does look as though you can show witnesses all of the documents in the case before when you're dealing with a witness statement, but you must exercise particular caution so that their evidence isn't swayed by any leading questions that might be asked about them, and so on. And then they have to be put in the list. This is my suggested list. It will show what the document is. The practice direction specifically retains the rules about privilege, but you are supposed to put privileged documents on the list, but you just put, a bit like in a disclosure list, you state that they are privileged. And so that's the sort of thing that you'll be putting on the end of the statement. So just to conclude then on documents that you refer to a witness, you're going to have to be quite careful to select in advance what documents you're going to go through, because those documents are going to have to go in the list. It may well be thought that the fewer documents, the better, particularly if they're not going to be referred to directly. And I'll deal with that in a moment. No leading questions, and of course, the Code of Conduct from November 2019 specifically says that a solicitor must not seek to influence the substance of the evidence. And just then, as a sort of commentary, whilst it is easy to see how this will work with third-party witnesses who might just be giving evidence about one aspect of the case, what about your client? It won't just be the preparation of the witness statement, which involves looking at all the documents in the case. Self-evidently, in a complicated case involving quite a lot of documents, you're going to be looking at those documents with the client, probably in one of the initial meetings, when they bring them all in to show you? What about when the pleading is drafted? Quite often nowadays, I will sit in a room with my laptop with the client, dealing with the pleading directly, because it's a economical and efficient way of doing the pleading, and documents will be referred to. So in order to put documents on the list, do you need to put documents on that have been referred to previously for the purpose of advising about the case initially, or doing the pleading? The question is an interpretation, really, of the words of the statement of best practice for the purpose of the evidence set out in their trial witness statement. My view would be that if you took a restrictive view of those words, documents which they've looked at in order to take advice or to do the pleading probably don't fall within the ambit of that. I don't know whether, Geraint, you've got any view about that point.
It's one of the unknowns. I agree with you that the wording of the provision is about your requirements in relation to the taking of the statement. So it does seem as though these requirements are linked to the stage of taking the witness statement and not earlier times. I suppose that one thing you would need to think about is whether you need to be transparent about the witness if they don't particularly remember something, if they're a bit hazy about something in terms of their own recollection, but that a document that they've seen previously has reminded them of something. They might want to say that, I suppose.
Well, let's deal then with the documents that the witness is not just going to be referred to, but the documents which the witness is actually going to talk about. We're all familiar, I think, with the sort of statements that this practice direction was aimed to prevent. Ones which go on for ages, just giving a narrative about all of the documents, or even worse, in my experience, I have come across these, which is where there isn't really any direct evidence at all. So in other words, rather than just saying on such and such a date, she came and dumped an old mattress in front of my front door, they say on such and such a date, I wrote a letter to the council saying that such and such had dumped an old mattress in front of my front door. So those are the sort of statements which this practice direction is clearly aimed at. That's actually been commented on now in another reported case, the Mad Atelier case, Sir Michael Burton, retired commercial court judge, the provision of absurdly lengthy witness statements, merely reciting the content of documentary evidence and commenting on it. And of course, that injunction is set out explicitly in the statement of best practice at paragraph 3.6. It's easy to know what not to do, but knowing what documents actually refer to is more difficult. The general rule set out in the statement of best practice is as few as possible, but subject to the following two categories. So on the left, you've got the documents which are necessary to refer to on disputed matters of fact. So, for example, if there was an issue, a crucial issue about, for example, whether somebody had been told something, the witness might say, well, I see that the other side denied that I ever said X, but I know that I did because I sent an email to somebody about doing that on that evening. And I didn't remember the email very well until I'd had the interview to prepare this statement, and my solicitor showed it to me. And now I can see that I sent it at 5:30 p.m. So that's the sort of approach, I think, that's now being encouraged. On the right hand, you've got categories which are fairly self-evident, proving or disproving authenticity, explaining the way things were understood, confirming what the witness saw or did not see at the relevant time. The interesting point, I think, about subparagraph 1 there is the content of the document. That might mean that it's actually quite broad. So if the other side, for example, had produced a document with content in it that you don't agree with, query whether that opens up the ability to refer to that and say why it's wrong. Well, let's just seek to apply this these two categories then to some of the things that we see in property litigation witness statements. The first, one of the first things that's often referred to when you're dealing with a property dispute is the title. So your witness may well have said, you know, I, with my partner, am the registered freehold proprietor of Blackacre. Pages 1 to 3 of AB1 is a copy of my registered title. Now, you wouldn't have thought that that would be a problem, but if the title is admitted, the document is not relevant to a disputed matter of fact. And so the evidence isn't required to prove anything at all. So that part of the narrative, strictly speaking, comes out. Imagine a case where the other side's disclosure contains documents, say an email or a letter, which is very, very damaging to their case. Can the witness say, I refer to Mr. X's email of such and such a date. This proves that what I am saying is right because ... Now that as well apparently falls foul of the practice direction because it doesn't really fall into one of the permitted categories, possibly with the exception of the content reference in the right-hand column that I referred to a moment ago. Those are the sorts of documents that in any event you're going to be putting to the other side in cross-examination. But it doesn't look to me as though that it's within the spirit, at least, of the new practice direction to be referring to the other side's documents and saying whether you agree or disagree with them or providing a commentary. Now, this raises an interesting problem about documents, in my opinion. If you have documents which are disclosed by the other side and might be damaging to their case, let's say they don't refer to them in a witness statement either. How then is that document, let's say it's a damaging email, is it even in evidence at all? Because documents don't just prove themselves, they need to be adduced into evidence, and the contents also aren't just automatically in evidence, they need to be put in evidence by a witness. So that's a problem, isn't it? Because if you can't refer to a damaging email that comes from the other side and they choose not to, how's it going to be in the evidence at all? Now, in the case of the damaging email, it might not be such a problem because I suppose what you can do is you can put that to the witnesses on the other side. And if they say, oh, well, yes, that's my email, it's not a problem. But think of some more nuanced problems that we encounter. Old deeds. You might say in a property dispute, say a boundary or something to do with an old right of way, I refer to the deed of the 27th of January, 1872. This deed was with the other documents, which when we received in a packet, when we bought the house, the deed plan shows a line. And I say that that's probably a hedge. Now, this again has been explicitly ruled out as commentary under the new practice direction. It has to be accepted that at the moment, there's a widespread practice of doing this in property disputes. And it's difficult to see what's going to take its place. The more sparse witness statements become in accordance with the new rules, the more, in my view, the law of evidence is going to come to the fore about admitting these documents at trial at all. And in my view, that's a shame because the law of evidence about getting documents in evidence, as my research that I've done for this talk has shown, is utterly impenetrable. There are some pointers, though, I think, which we just have a quick look at. The first is that the authenticity of a disclosed document is deemed to be admitted unless there's a notice served understand the limitations of this provision, CPR Rule 32.19, because all that really refers to is the document being authentic. It doesn't say anything about the contents or the fact of the documents being sent or anything like that. It's just that it's not a forgery, and it's not, and really that the copy in the bundle or that's been disclosed is genuine. Then you've got paragraph 27.2 of CPR Practice Direction 32, which is about documents being admissible as evidence of their contents if they're in a trial bundle. You might think, well, that solves the problem. But of course, the fact that they're admissible doesn't mean that they're actually in the evidence. They're just admissible as evidence. And that appears to be the view of the authors of the commercial guide, who refer to the need, notwithstanding this provision, still to admit documents in evidence. And just before I go on to how to do that, I would note as well that that first subsea decision there would tend to suggest that for some documents which might fall within this rule, you actually need to serve a hearsay notice anyway, so they wouldn't even be admissible. So how do you admit things in evidence if they're not, if they're covered by this rule and the rule doesn't do the trick? The Chancery Guide talks about writing to the other side when you do the bundle and asking them to agree that the evidence in the document shall be admitted. And if the recipient of that request doesn't agree, they have to write a letter to the court explaining why. I have to say, I've been doing chancery trials for 22 years now. I have never seen that practice adopted. I don't know whether any of the participants have. Geraint, I don't know if you have. No?
Nope, never have.
The commercial court guide says that if you don't get agreement about admitting the documents in evidence, then apparently you're supposed to invite the judge to read the document relied on before calling oral evidence. I have to say, I'm not entirely sure that even that puts it in evidence. Now, how do we avoid all of this becoming a costly mess? Well, one thing you could consider is having a sort of standard direction now in advance of a trial along the lines that I've drafted here, whereby the evidence that the documents are agreed as evidence of their content, unless that content ought to have been in a trial witness statement. Then that's one way of doing it. But just some practical points about all of this. The shorter and more sparse witness statements become, the more thought you're going to have to give to how documents are going to be proved at trial. Take the early view of your trial advocate. Give consideration to how this is going to be, how much this is going to cost in terms of time when preparing cost budgets, particularly in the trial preparation phase. So that's that. We'll have to see how we get on, I suppose, with that aspect of things. There's another category of document, I think, which we need to consider in property cases, and that's this. In well-prepared property trials, there will have been a plan drawn up, at least if the property trial is about, where things are on the ground. It's useful, in my view, to draw up these plans before witness statements are done and get them agreed. So that's because there can be a sort of common hymn sheet, if you like, where all the witnesses in the trial can point things out by reference to a common underlying plan. This is absolutely crucial, of course, in boundary litigation, where your pleading actually should have a scale plan on it anyway, because you're going to be asking the court to give a declaration about the boundary anyway, and it can't do that unless it's got something to do it with. The arrows that I've put on the slide show my preferred way of showing things to the judge with photographs. So you would have photographs 1, 2, and 3, and the witness would say, this is the garage door, this is the bushes by the side of the house, or whatever. And you could do that with the arrows showing the direction that the camera was pointing in. Now, it has to be accepted that this practice direction was not written with this sort of document in mind. By the way, Lady Hale agrees with me on all of this. There's a good, quite useful dictum of hers from a Court of Appeal case from 2007, talking about the importance of maps, diagrams, or photographs, and that there be at least one that everyone agrees on. So you could refer to that if you're getting any objection to using this type of document. But can you use this type of document? Does it fit in to the documents that you're allowed to refer to as set out in the practice direction? At first sight, no. Paragraph 2.1 of the practice direction states that the purpose of a trial witness statement is to set out in writing the evidence in chief that a witness of fact would give if they were allowed to give oral evidence at trial. So really, your evidence is confined to a written account of what evidence they would speak from the witness box. Plans and photographs done for the purpose of explaining the case don't readily fall within those two categories that I showed you in the slide earlier on. So what's the way around this? I think, well, firstly, I don't think you're going to get any judicial pushback for useful photographs, useful plans prepared for the purpose of explaining a case. In my experience, judges are going to want to have that sort of thing in, and will interpret the rule to allow that to be done if they can. I think the best point to make is this, that if a witness is giving examination, is giving evidence in chief in the witness box, they can in fact be shown agreed plans and photographs when doing so. That is common practice, I'm told, by a criminal practitioner who I've asked in criminal trials. There's nothing to prevent a witness being shown an agreed plan and asking in chief to point things out on it. Quite a lot of the research I've done, by the way, about examination in chief has been done by watching episodes of Crown Court, the 1970s television drama. It's very good, actually. So there's that, and in fact, in that episode, that's exactly what was being done. The witness was being shown an agreed plan. So I think that's your argument. You can say, well, if the evidence is going to be limited to evidence in chief, the witness can give evidence in chief about plans and photographs. So conclusions then on references to documents in the new trial witness statements. Don't do a narrative about them. That's obvious. The problem with that then is that there won't be really, or it's difficult to see that there'll be an overall narrative about the case before the judge when the case comes to trial. The pleadings are probably going to be too short to give a full picture. And in any event, they're not really a sort of personal account of what went on. Skeleton arguments are for submissions rather than a full history of the case. You may have, I suppose, a direction for draft openings. That's probably how it will go, I think. I suspect if witness statements are going to be short, then that's what the court's going to direct. So put provision for that in your cost budget for trial preparation. Ominously, I think, the Witness Evidence Working Group recommended that the idea of the production of pre-trial statements of fact be considered by individual courts within the business and property courts. Now, a pre-trial statement of facts would be another document in itself, which would add a layer of preparation to the work to be done before a trial. I think it will be particularly difficult if that pre-trial statement of facts had to be agreed. It's already difficult enough agreeing chronologies, agreeing even agreeing case summaries can be difficult with some opponents. They just won't agree anything. If you ask them to agree that we should go and get a glass of water, they'd raise an objection in some cases. So I think that's a prospect to behold with ominous apprehension, really. If the courts now are going to start ordering pre-trial statements of fact. I'm not sure if they will, but they could do. And again, just be aware of that prospect when doing cost budgets. So just some final conclusions then on all of this. The aim of all of this was to have more focused witness statements. Obviously, that's a good thing. The idea is, I think, if you cut away a lot of the commentary, it makes cross-examination shorter. And certainly from a personal point of view, if I'm preparing a cross-examination, it is very difficult sometimes to know what to ask and what not to ask, because there's all this sort of marginal stuff that probably isn't direct evidence, but you nevertheless feel that you ought to challenge. So that's a really good thing. I think the difficulty then comes, though, in this emphasis on the sort of mini examination in chief that has to be done during the interview, if you can call it that, and the focus on the genesis of the statement, and the emphasis in the practice direction on the statement being done with as few drafts as possible, and that nothing being done to taint the witness's recollection. The danger is that that's going to then prompt advocates at trial to start focusing on how the statement was produced, with questions like, well, how many drafts did you do of this, or, how many meetings did you have to do it, and so on. And I think that really will be quite sterile and unproductive. And in any event, it's very difficult to know how far you can go with those questions, bearing in mind that the law about privilege, which of course has been retained. There was in fact a proposal to lift privilege on the documents generated by the production of statements. So all in all, I mean, the focus is a good thing. One hopes that it won't end up leading to more time at trial. It probably will, in my view, lead to more time being taken in the taking of the statements. And just finally, I suppose, I did say I wasn't going to do a talk just going on and on criticising the practice direction, but one thing I would say is this. Some commentators have remarked that this practice direction, the disclosure pilot, and indeed the introduction of the Business and Property Court itself heralds the ascendance of the Commercial Court over the Chancery Division. That may or may not be right. Certainly quite a few of the members of the working group were commercial practitioners. But one thing is for sure, in my view, the practice direction could have benefited from some good chancery drafting. I doubt I'm the only one to notice the irony of this, that they're doing an injunction to the profession to focus, to use language which is natural, and the practice direction in which they do it is prolix and full of arcane, old-fashioned terminology, not least the repeated reference to examination in chief, that elusive concept. So I think that's me done. Over to you, Geraint.
Thanks very much, Matt. If you wouldn't mind just stopping sharing your screen, please. Just while we get there, I'm going to just send you the second of our questions on our poll. So the first question was about whether there has already been an improvement brought about by the practice direction. And this one is about whether, if we haven't seen it yet, or you don't yet know, whether you think that we will get to an improvement in at least the medium term. Now, I said at the beginning that I'm going to talk about a range of matters. I'm just going to pick out a few topics to talk about. There's no particular structure to this. I'm also going to talk about what case law there is. And I don't know about you, Matt, but it struck me when I was researching this that there really is barely any case law. We've been going for a while now. And given how important this is as an issue and how difficult it is to understand what the practice direction really wants from us, I would have expected there to be an explosion of applications that have been reported.
Paul Chasty told me that he's seeing in the business and property court quite a few challenges now in the pre-trial review stage to the content of witness statements. It's probably just the case they're not being reported.
Yeah, well,
that's anecdotal.
Yeah, I mean the case in terms of the authorities, there's the global case that you mentioned, Matt, and then there's two other High Court cases. Both of those are were applications made at the PTR stage. I'll go through those. As part of the preparation for this, I spoke to a number of property litigators to gauge their thoughts about how things were going, and one very well regarded partner was telling me that it seems to be seen by some as a pedant's charter, was his word, which brings me to sharing my screen and bringing this up at the moment. So this partner was telling me about a case in which the witness statements from the other side were terrible, disjointed affairs. Sterile was a word that you used before, Matt, about this, and the almost bullet-pointed witness statements with no life or flow to them. So that's what he had in from the other side, and of course when the other side received his witness statements, that prompted a flurry of objections, apparently to all manner of aspects in which it was said that the practice direction had been breached. So it remains to be seen what happens to that particular one. But other solicitors were saying, in fact, most solicitors who I spoke to were saying that they don't see the practice direction as bringing about too many fundamental changes to what ought to go in a witness statement. There's the provision about documents, which really is different. But in terms of witness statements not arguing the case, witness statements not containing lengthy commentary, and witness statements being meant to be written in the witness's own words, this is nothing new. But anecdotally, it's clear that there's tension in terms of the different ways in which you could interpret the practice direction. We don't yet know how strict the courts are going to be. It was hoped when we originally mooted the idea of doing this talk that by now we would be in a position where we had a reasonable amount of authoritative guidance on it, but we don't really. The High Court cases that I'm going to refer to, first of all, the Mad Atelier case. For the foodies amongst us, that is Joël Rebouchon, who is a Michelin-starred chef, and his restaurants sparked this particular case. It was a commercial case dealing with a joint venture. The idea was that a chain of these restaurants would be created around the world. It was said that there'd been fraudulent inducement into that JVA. And as a result of that, quantum was an issue. And in particular, there was, it seems, evidence of fact going to what would have happened in relation to these restaurants. So what level of profit was expected, and why there was such an expectation. And so the witness statements of fact went into hypotheticals in order to be able to address this point about loss of anticipated profits. And it got to the PTR, and the other side applied to strike out certain passages from those witness statements. And the judge rejected this. The judge said that you can't just assume that because something is hypothetical, it's not permitted under the practice direction. There are elements of the statements of best practice which give a clue to this. So I've set them out there. Your thoughts are matters of fact. What you would have done if circumstances were different are matters that can properly form part of a witness's evidence of fact. The general tenor of the report is quite interesting, in that there's not an enormous amount of analysis of this stuff. But what appears to me, at least, to be clear from the report, is that the court was really not keen on the idea of excluding potentially relevant evidence. What the court was wanting is the ability of for the trial judge to make his or her mind up, to weigh it all up when it comes to it. The second case, Easy Group and Easy Life, that's Stelios, the founder, I think, of EasyJet, and it seems a company that I wasn't aware of called Easy Pizza. And this was a trademark infringement and passing off case, as you might have guessed from the name, Easy Group against Easy Life. The Easy Life adduced 6 witness statements from witnesses who were apparently saying, well, we weren't confused by the similarity in name between these two. The application was made at the PTR to strike out, and the basis of that was that apparently these witness statements were derived from witness questionnaires, which it was said contained leading questions. And as we know, witness statements are supposed to be provided these days by a process which involves open questions rather than leading questions. And again, the application was refused. And what the judge seemed to focus on in this case, again, without it must be said, an enormous amount of analysis, is this concept of transparency, which I mentioned in answer to one of Matt's questions before. And it's something that I've seen members of the working group talk about in other seminars. But part of what underpins these reforms is the concept of transparency. And the reason for that is that they want the trial judge to be in a position to assess the quality and veracity of the evidence. And if the trial judge doesn't know how the evidence was procured in the first place, the judge is hindered in that respect. But in this case, because it was known that these witness statements had been procured by reference to these witness questionnaires with potentially leading questions, the trial judge, they could explore that issue at trial, and the trial judge would be able to make his or her mind up about it. The other thing that was quite striking about this case is that it might be thought that where you've got an applicant trying to strike out parts of what you might call offending witness statements, if those witness statements go in to the trial, it will be the applicant who is at risk of detriment, of harm, prejudice. But here, what the judge said was that actually it's the other way around. The party putting forward potentially tainted witness evidence is the party to suffer the potential prejudice at trial, he said, because the evidential value of those witness statements will be reduced. So in both of these cases, the Easy Group case, the Mad Atelier case, and the global case that Matt referred to, what we see is what you might call a sensible, inclusive approach from the court. It remains to be seen whether future decisions follow this pattern. It's probably too early to call it a pattern as yet. I don't know whether we're going to have a Mitchell moment where the fear of God is struck into all of us, and suddenly we're all supposed to do things absolutely by the letter. Personally, I suspect not. I suspect that there will be that these rules will be applied in a common sense manner. There will always be outlying decisions, but generally speaking, I suspect we'll have common sense approaches. Note in the two cases I've referred to, the applications were to do with striking out witness statements or passages in witness statements. There was no discussion of the range of sanctions that are potentially available to the court and set out in the practice direction. I've set them out there. I'm not going to go through them because they're fairly straightforward, but one thing that it occurs to me about is that 5.24, the requirement for the witness to give oral evidence in chief, so that in theory, faced by an offending witness statement, the judge can say, right, well, I'm going to tear up that witness statement and I'm going to force you to give your evidence at trial in chief. Now, that will be an appalling moment for trial counsel when he or she hears that, because unless they've been doing the job for an awful long time, they won't have done much, if any, evidence in chief. And you know, Matt asked me before if I had ever done it. The last time I did proper evidence in chief was at bar school, and I just remember desperately trying not to keep repeating, and then what happened to my pretend witness. But aside from that, the real party to lose out, it seems to me, if a witness is required to give evidence in chief orally, is the other side. Because the other side then are a complete hostage to fortune. You've no idea what's going to come out in evidence in chief. So if you're wanting to complain about the other side's witness statements, you want to fight tooth and nail, I would have thought, to avoid the judge helpfully imposing this as a sanction on you. Redrafting as well could be something that you as the innocent party don't want, because depending on the time at which this point is taken, you might end up getting in a completely new witness statement relatively close to trial, that could, in theory, unless there's a very strong direction to the contrary, contain new evidence that you weren't prepared for. I've seen it said that the redrafting option might be more popular amongst judges than the getting the blue pencil out and crossing out various passages or paragraphs in offending witness statements. I don't know, Matt, whether what you think about that. I mean, personally, I would have thought that as long as it's fairly clear, the blue pencil will be more likely.
I think so, yes. I mean, I suppose in some cases they might just make them do it again. It depends as well on the stage you're at, but it seems to me if there's 3 or 4 paragraphs that fall obviously outside the rules of what you're supposed to do, then there's no reason why they couldn't just be struck out. I don't think that, I mean, some of the judges, when I've been watching some of the talks, they've almost been sort of talking about this practice direction with a sense of revenge on the profession for having done such poor witness statements for so long and making their life difficult. So I don't know, who knows? They keep saying, well, you know, you've had this coming. So we'll have to wait and see, I suppose.
Yeah, I mean, I think that overall, I don't think the courts are going to be keen at all to entirely deprive a party of their witness for breach of the practice direction. If that witness is able to give relevant evidence, I think that the courts will strive to find a way to allow them to give relevant evidence. Particularly egregious breaches are a different matter, but I think that sanctions which entirely kick a witness out, I would have thought will be reserved for the most serious of cases. Now, when we're trying to interpret a document, for example, a statute, we often think about the purpose, we think about the mischief, and the same goes for interpreting this, it seems to me, that the aim of the practice direction is to get rid of this form of witness statement, the lengthy, argumentative and overly lawyered statement. The reason they want to do that is because those sorts of statements make it harder for the judge to work out who's telling the truth and exactly what has happened. It's difficult to work out what the witness actually knows and sort the wheat from the chaff. Now, apparently, this whole set of reforms was born of commercial court judges sitting in the Crown Court from time to time, and apparently they were really impressed with the quality of the evidence that came out in chief, and it didn't make a very good comparison with the sort of fare that they were served up on a daily basis back in the commercial court. So they got sick of the typical commercial court witness statements, and then thought they would try to import the ideas of evidence in chief into the B&PC, and we end up here. Now, as a result of that, and as a result of this being a drive to improve the quality of the evidence, and therefore improve the quality of the trial, and therefore improve the quality of the decision making, this isn't, it seems to me, part of the cost-cutting rules for rules' sake drive that we've seen in other areas in recent times. As I say there, it's when you think about the purpose, and the purpose being to improve the quality and reliability of the evidence, you can potentially use that as in difficult cases to work out what should or shouldn't go into your witness statements, and when you're scrutinising the other side's statements, and also when you're thinking about potential sanctions. So, what sort of sanction would meet the breach? How would you? What sort of sanction might allow for the best evidence to end up at trial? Then the thing to think about is whether these reforms will have a wider impact. They don't apply in the county court, even a county court that does business and property work. Any county court procedural judge could order compliance, though, and as I say there, that the template in the Central London County Court for B&PC work includes compliance with the practice direction. You will always get individual judges and potentially court centres who are really keen on this as an idea. And Matt, I don't know whether you'll be able to name names, but I know that you've spoken to a very senior county court judge about whether the judiciary will be keen on this or not.
Well, I bet I haven't, but I mean, certainly from that, the judge I did speak to, they are keen on it. They're very keen on it, and indeed, as I said just a moment ago, from watching some of the seminars where judges have been involved, you can see that they were, really chomping at the bit for something to happen. Query whether it needed to be such a radical change. They had the armory there already to impose sanctions for statements, including lots of commentary and lots of legalese, as it were. But no, I think they are. I think they're quite on board.
Yeah, no, we all know the sort of judges who we get in, who are sticklers for the rules, and we get the more laissez-faire judges, and certainly I can see that some district judges, some circuit judges or recorders, it'll just become a standard practice for them that they will require compliance with it. The bottom bullet point there, reminding county court judges of pre-existing rules. I put that in because last week I did a PTR where the other side were asking for permission to put in some late witness statements. And although the judge didn't refer to the practice direction, I suspect that the existence of the practice direction has refreshed judges' minds that there are pre-existing rules about the content of witness statements that do apply directly in the county court. And so, for example, in my case, permission to rely on these late statements was refused after the judge went through a process of assessing these witness statements for relevance, assessing whether they contain sources of knowledge, attribution of where the content of the witness statement comes from, commentary on documents and arguments. Because the judge wasn't very impressed that these statements contained all of these things, he rejected it. You can think about tactically whether it suits you in your individual circumstances of a case to ask for a direction that the practice direction be applied in the county court. You might have an opponent who is prone to huge letters arguing the case in correspondence, and you can just imagine what sort of witness statements you're likely to get from such an opponent. You might have an opponent who you think is being dominated by their client, and you think that the practice direction might bring some discipline to the witness statements. Things like that you could have a think about and seek your direction. Now, I've touched on this, and so I'm not going to spend a huge amount of time on it, but the need to consider how to get your documents before the court is something that we all need to think about. You can't weave them all into a single witness statement in the same way anymore. You can't tell the entire story through a single witness anymore by reference to the documents in the same way that you used to do. So how do you do that? Well, first of all, don't just lump everything into the trial bundle. There are rules about relevance in trial bundles anyway, but if you don't just think that because the witness statement can't go through the documents, therefore all the documents need to go in. Also, more and more cases are being determined by reference to email traffic, and judges despise endless repetition of email chains. As each email is replied to, we get the original email, and then the reply, and then the reply to that, and the reply to that, and it builds up and builds up until you have hundreds of pages that might cover only about 20 emails. So try to avoid that sort of thing, because if the documents are going to need to speak for themselves, what you want is for them to appear in the most intelligible format, most user-friendly format. So a bespoke, ongoing, chronological narrative document. This would be a new form of document that you could consider deciding to create for yourself in your given case. You would build it up over time. It would take the place to some extent of the witness statement that tells the story via the documents. So you could refer to documents, you could comment on documents, you could refer to what points you seek to draw out from those documents. If you get it in front of the judge, it could stand as a part of a written opening. And you may even find that if the judge finds it useful, it finds its way into the judgment. It's always good if you can help the judge with his or her judgment. You could, if the case demands it, you could do two versions of it. You could have a sanitized version for the court and a warts and all version full of colourful language between you and counsel, discussing the case and ideas for cross-examination, that sort of thing. So it could become a useful tool as you go through the case. If you're going to want counsel to draft a document like this for you, it will take time. You will know from your own experience of drafting witness statements that do go through all the documents, how long that takes. So if you're going to want counsel to help, trial bundles will probably need to come in earlier. You may need to make provision in the budget. Sorry, I should make that clear. You definitely will need to make provision in the budget for an enormous fee for counsel. Again, Matt touched on this. Really try to avoid a direction for an agreed document of this nature. You'll just never manage to do it. It'll be horrific. So, poll results. If I can just, we asked you whether the practice direction was already leading to an improvement in trials, and the answer to that was that 5% of you thought that there was already an improvement. 13% of you thought that trials were not already improved by the practice direction, and 81% of you didn't yet know. Now that's the large percentage of don't knows isn't surprising given that we haven't been on for too long. But the not already improved being over twice the already improved isn't a ringing endorsement. And as far as the medium term, which was the second poll, 38% of you didn't know. 19% of you thought that the trial process would be improved in the medium term. 43% of you thought it wouldn't be improved in the medium term. Now that's quite interesting, because back in February, when we hadn't even started all of this, at that Leeds Business and Property Court Forum seminar that I mentioned earlier, 64% thought the reforms would improve the trial process. So over the few short months that we've had since then, there's been a real drop-off in enthusiasm and expectation that this will help, which I think is quite interesting. So very briefly now, judicial notice. This is where the court takes, when the court takes judicial notice of something, it means that you don't need other evidence to prove that thing. And there are various odd categories of it, to do with things like parliamentary procedures and matters of war. And that's the example there of Germany and having coaling stations. There's the one there that we will all know about, the OS maps and lines being drawn through the centre of hedges. But the main one that we come across on a day-to-day basis is notorious facts. So acceptance by the court of facts or a state of affairs which are so notorious or so clearly established that evidence of their existence is deemed unnecessary. If you want to rely on judicial notice, you bear the burden that you have to show that it's so notorious as not to be the subject of dispute among reasonable people, and then that, or alternatively, that you can immediately and accurately demonstrate it by resorting to readily available sources of indisputable accuracy. And that was a Privy Council case from a few years ago. A good example of it fairly recently, the Monroe and Hopkins defamation case about Katie Hopkins, the apprentice contestant, about Twitter. So some of the obvious basic stuff about Twitter you could take judicial notice about, but the detail of how Twitter works, you couldn't. So common sense there. But you only have to go back as far as 1984 to see Lord Diplock saying that the court could take judicial notice that a particular type of marine insurance policy was widely used in many countries of the world, including, other than those countries of the Commonwealth that have enacted the statutes in the same terms as the Marine Insurance Act 1906. Now, how that could be considered to be common knowledge and incapable of dispute amongst reasonable people, I don't know. The real point about judicial notice is that you don't want to have to rely on it. You should have all the evidence that you need in advance. It's really random as to whether the court will accept that they can take judicial notice of something. And the final example of that is this recent case in the Court of Appeal, which was about a landlord's rights of entry onto the demise premises. The landlord wanted to install bat detectors on the demise, and that whether he could do that depended on what these detectors were like. What the Court of Appeal was considering was whether there was enough evidence for the judge to decide that the landlord was entitled to put bat detectors up. And there was evidence at trial that these particular bat detectors were a proprietary product called Anabat, and there's a photo of Anabat there on the right. And what the Court of Appeal said is that even a cursory search of the internet will find the website with a product description and picture. A judge may take judicial notice of matters which are capable of immediate, accurate demonstration by resort to readily accessible sources of indisputable accuracy. So there's the Court of Appeal, considering that a Google search online might be a source of indisputable accuracy. Of course, they're not in truth saying that. They wanted to find, they wanted to uphold the decision, and it would be a very brave party to rely upon the court taking judicial notice of something they can have a quick check online about. So just beware of that Earl of Plymouth case, because I suspect it will be pretty much confined to its facts. Thank you very much indeed for listening. I'm just going to check the Q&As. Someone has said, I recently had a case in the Central London County Court, which was in the Chancery business list, and was told by our internal PSLs that the practice direction does apply to the witness statements I needed to prepare. Do I agree with that? Well, this goes back to the template directions, that It doesn't apply as of course, as far as I'm aware, in the CLCC, but that as a matter of practice and as a matter of course, if that template is used in any particular case, then you will find that the requirement will be in there. But given it's a statement of best practice, it's as well to have an eye to the practice direction anyway.
I think just on that, in the Central London County Court Chancery Business List, one of the commentators on the Chancery Bar Association talk was His Honour Judge Monty, who's in charge of that list. And I think it does apply just in the Central London County Court, according to him.
Well, he said that it was going to, didn't he? So I thought that one as well.
So I think it might, look, I think the point is, apart from the Central London County Court, it doesn't at the moment apply in county courts, is how I understand it. So that your colleague's reference is probably consistent with what His Honour Judge Monty was saying.
The definitions of the problem with the practice direction is that it doesn't tell you what business and property courts means for these purposes. You have to look to one of the other practice directions. I think it's 57A that talks about what the BPCs are. And strictly speaking, the BPCs are all High Court level courts. There's one other question on the chat. I can see this expanding the gap between statements produced by clients with legal representation and those of litigants in person. Will the court make greater allowance to the litigant in person? And if so, might this prejudice the party with representation? Well, there are specific points about litigants in person in the practice direction itself. There's in the statement of, it is in the statement of best practice. I'm just going to it now. There's a section for represented parties, and there's a section beginning at 3.14 to 3.16 dealing with litigants in person. Any witness providing a trial witness statement should read and understand the statement set out in paragraph 4.1 of the practice direction before any witness statement is prepared. That applies to a litigant in person in relation to their own statement, as well as to other witnesses. The litigant in person should understand that any trial witness statement must set out only what the witness providing the statement says and known personally to them. So essentially, with litigants in person, there are specific rules which you can look up to see the detail, but broadly speaking, the thrust is the same, or at least very similar. Generally speaking, despite what the Supreme Court said relatively recently about litigants in person, we all know that in practice they get greater leeway. But they're not. They don't have a free run, is the answer.
I suppose if the whole thing is aimed at the danger of over-lawyered statements, there's always going to be the suspicion that where a witness has got good lawyers acting for them, that they may well have had words put in their mouth. I suppose doesn't apply in the case of most litigants in person. Having said that, I think they will be expected to comply to the rules as they're drafted for them. I think, on the face of it, the paradox is that it does seem to be an advantage to be a litigant in person when making a witness statement, because of the restrictions on what lawyers can do and the time it's going to take. Yeah.
Just had another question from Elizabeth. We have a similar matter in the Central London County Court where witness statements are due to be filed on Friday. We have prepared them in line with the practice direction. Could we be criticised for doing so? I don't think you'd ever be criticised for doing it in line with the practice direction. If again, to make the point from before, that these are, whether or not they've been ordered to be provided in accordance with the practice direction. The practice direction refers to the requirements as best practice, which I've thought is the best cover you could ever have for preparing something in line with its requirements. And again, fundamentally, this doesn't reinvent the wheel in terms of what a witness statement should cover. The focus on a witness giving evidence that they know about, that they can actually talk about, is something that people should be doing anyway. I think that's question and answer. What about a witness statement in support of a Part 8 application? Part 8 trials are included, I think, aren't they, Matt?
They are, yeah. So it does apply to Part 8 peculiarly. How, therefore, to do a Part 8 witness statement is a difficult question. I suppose, I mean, on one view, though, with some Part 8 claims, they won't be going to what you normally refer to as a trial, because they're obviously Part 8 is conceived for cases where there is no substantial dispute of fact. Some cases which are brought by Part 8 do indeed have very substantial disputes of fact, in particular Inheritance Act cases and Talata cases, which are generally brought by Part 8, although they don't have to be. I don't know what the answer to that is. I think I would suggest there's no pleading, you see, that's the problem. So I think you would have to set out by reference to the documents what the case is in the witness statement, and ask at the first return date if there's going to be a trial on any disputed matters of fact, for the first witness statement to stand, if you like, as a pleading, and for any further issues of fact which have arisen once you get the statement in response, if it's necessary to do so, to be dealt with by trial witness statements under the practice direction. But I mean, that's just a circle which is impossible to square, really. I mean, you can't set out a case without a pleading in one of these new witness statements. Yeah,
and in fact, this just picks up on a point that Rhiannon's making on the chat, which I'll come to in a moment, that the definition of the practice direction refers to trial witness statements, and trial is defined in the practice direction as a final trial hearing. In any of the BPCs under CPR Part 7 or Part 8. So you need to think about whether your Part 8 hearing is the final trial hearing. And to pick up Rhiannon's point, Rhiannon says, refers to this final trial hearing. Presumably this excludes final possession hearings. There's a case about possession hearings, and I can't remember which way it went on that. There's a case about whether it's classed as a trial or not.
It was for the purpose.
I'm afraid that's not very helpful. It either does or it doesn't.
It's for the purpose. Is it Force, Lux, and Binney or something?
That's one. There was another one.
If you look in the white book,
Harry, maybe.
Yeah. If you look in the white book, there's a whole. I think there might even be one or two cases on what the status is of those first return dates on a possession hearing, and whether it's a trial or a hearing. I mean, difficult though it is to conceive of how we could have got ourselves into a position where the Court of Appeal would have to spend hours and hours dealing with that sort of thing. So have a look. I can't remember off the top of my head what the answer to that is. So I'd be happy to have a look at it on the email if you want to. But the first return date of a possession hearing is a funny sort of hybrid thing, because it does amount in some respects to a final hearing in many cases, because there won't be a defence. If you're doing a witness statement for one, does the practice direction apply? Answer, probably not, because you're going to be in the county court. So that's the way of dodging the question. Unless you're in the Central London County Court Business and Property List. But if just for a normal possession hearing, you won't be in the Business and Property List anyway. That's my answer. But there is, I think it's under 39.3 as to where somebody missed a hearing. So anyway, that's all I can help with on that. I'd be happy, if you want me to have a look at it, Rhiannon, I'm happy to do so. Is there anything else? Should we better?
No, Rob Bailey has made the same point about final trials again. So again, Rob, if you want to email about that, then we can pick it up then. And I think we've exhausted the questions and probably everyone's patience. I think that will be it. So again, thanks to Elizabeth and to the PLA. Oh yes, there was one question about whether the slides will be available. Yes, the slides will be available. I'm not quite sure whether they're going to be sent out as a matter of course to all attendees, or whether you would need to email someone. I don't know whether Elizabeth is still on and able to help us with that. She says a recording will also be circulated, which is very useful. Thank you. Essentially, if you don't get a copy of the slides automatically within a couple of days, just email marketing@kingschambers.com, and they'll be able to send you out a copy of our slides. So it's marketing@kingschambers.com. Okay, thank you very much. Bye-bye.
Thanks, everyone. Bye.